Your Honor, I can tell you that my client reached out to Midland Mediation to schedule his appointment. He returned the required documents. I believe that the respondent has also done that, but I think a question has arisen from the mediators about whether it's likely to be successful. So they wanted to see if the court wanted the parties to proceed to mediation or to use some other form of alternative dispute resolution, like domestic conciliation or something similar, is my understanding of what they told my client. But he has returned all of his required documents.
Well, the mediation hasn't begun yet, and the mediator is already questioning whether it can be successful or not.
Well, that's my understanding, and I don't know if they reviewed the file or they reviewed the case. I haven't spoken personally to the mediator, so that's just what my client was told.
Ms. Sewer, what is your view on things?
I haven't heard anything from the mediator whatsoever about her having a concern. So my client hasn't shared any information or been told that either. I thought they were going to be scheduled in February for mediation. So this is all news to me. So I can follow up with the mediator and see why she's saying that, but she hasn't received any pleadings or any paperwork from me. I don't think she'd have access to the court file. So unless Dad said something to her, if he was talking to her to schedule, or maybe from the paperwork they submitted, I don't know. This is news to me.
Judge, my client is just informing me that I believe that the mediator is willing to meet with them and told the family told my client that she has an opening, but not until February 11th. He has no issue with going to mediation. There was a kind of a pause or a question about whether it would be successful.
We go into these with the idea that it's going to be successful.
I agree.
The parties are going to talk things out, and they're going to try to reach an accord as to what's in the current best interest of the minor child.
I agree, Judge. And they have been successful in the past at mediation. It may have taken more than one session. It may have taken 3 or 4, but they have typically been able to hammer out an agreement of some sort.
All right. Well, mediation remains the court's direction in this case. I would have preferred that we be fully engaged in it and perhaps even making progress by this point. But it does appear that the parties have done what they were asked to do. So now it's just a question of getting scheduled and started with the mediator, which apparently is going to take place here in just a couple of weeks. All right, then. Then probably the most appropriate thing would be to set another status conference. I don't want to lose track of this case.
I did file a couple of motions. There's an issue with therapy, and then there's an issue with the fact that my client had no parenting time whatsoever from December 24th through January 16th. I don't know if the court's open to entertaining those motions, or if you intend to pass those to mediation as well.
So during the Christmas season, Mr. Hunt didn't have Mr. Hayes, excuse me, didn't have any parenting time?
No, my client didn't have parenting time from December 24th through January 16th. She had a few days right before the Christmas holiday, but then he had the second chunk of the holiday. Then instead of resuming her every other weekend, the very next weekend, he said that was also his weekend. And so she didn't have the child at all for almost a month. And so I think she ought to have a weekend to make up. It's just not fair how that played out, or how he interpreted the order to her, not seeing the child at all. And he didn't let her have the child, like, any parenting time whatsoever during that almost month time.
Well,
let that go on till mediation or after mediation. I feel like she needs some extra time in February to make up for the lack of time she had in January, or else it from the child's perspective, if we give makeup time down the line, it's not going to necessarily make sense.
Ms. Gilmore?
Well, Judge, first of all, there's been a consistent issue in this case with mother and her grandmothers talking directly to the child about the schedule, about when she's going to be with mom, when she's going to be with dad, when she's coming back. And sometimes it happens that mom has misinterpreted the order. That happened in Halloween. There was a dispute over parenting time in Halloween. This specific Halloween, it was dad's weekend, but it was mom's Halloween. And instead of mom returning the child to dad, like the order said, she kept the child that weekend. There have been other issues like that. What she's talking about, the Christmas holiday, is that They had their every other weekend regular parenting time until the school break. When they started the school break, mom had the first half of Christmas break. Dad had the second half of Christmas break. There was an argument and a disagreement there even about the parenting time because mom thought that she got all the way until I think December 26th or 28th, which was not the case. The order was very clear. She got Christmas Eve, he got Christmas Eve night and into Christmas Day. There are our family wizard messages that evidence this that go back and forth where my client is trying to explain to her what the order says. She disagrees with him. My client said, look at last year. She picks bits and pieces of the order that work to support whatever her issue is or whatever her position is, and she ignores the other parts of the order. And that's what happened here. She wanted to go back to the every other weekend parenting time immediately when January 1st or 2nd hit, but school didn't start again until January 5th. So therefore, that was the reason for the long period in between her parenting time. It wasn't that dad was withholding the child. And when this disagreement arose the last time, my client, even though he felt like it was his weekend, met mother when she sent an Our Family Wizard message to him saying, hey, I don't know what happened, if you forgot or what. He's like, what are you talking about? This is my weekend. But nevertheless, he met her. He was going to go ahead and let her take the child for the weekend, even though they disagreed about whose weekend it was. And when they just said anything to the mother in a Walmart parking lot, she just exploded. She got out of her car. She was just yelling and screaming into the car with the child present. And so my client tried to de-escalate the situation and drove away. Mom then called the police, who contacted my client, who said, read the order, told the police to look at the court order. And no further action was taken by the police because it was my client's weekend. So this is an ongoing issue where there's a disagreement about what the specific dates are, and particularly that happens with parenting time. So I think the remedy to that is in mediation. Instead of saying mom gets Christmas, dad gets Christmas Eve, would be to specify the dates when you're looking at a calendar. For example, the school calendar gives you all the way through the end of the year. So dad gets, January 20th to the 26th. Mom gets the 26th to the 31st. Those dates would probably be immensely helpful to these parties, particularly because it seems to be a continuing ongoing issue with the misinterpretation of who gets what parenting time. So my client was going to be the bigger person and let her take the child anyway, until she acted in that manner. She then sent him an Our Family Wizard message and was saying she didn't know where the child was, and that's what she's filed in her motion. She didn't know where Paisley was, if she was at home alone. Paisley was in the car, and it's incredibly concerning that she didn't see Paisley in the car with my client's infant child, who was also in the car. So I'm not sure what the answer is here, but my client's not purposely denying her parenting time like she seems to be suggesting to the court.
Ms. Gilmore, actual dates for various special periods, such as holiday or Christmas periods, are going to vary from year to year. Are you saying that you'd need some structured multi-year specific date program set forth into some future order? How you define how the holiday period starts and how it ends, and then dividing it in half, it really isn't that tough. You divide it by 2. And I'm not trying to be condescending here, but like I said, most couples do not have this issue. Furthermore, the court has a standing policy, and I think it's almost across the board, that special periods override a normal weekend schedule. So simply they're replaced by whatever special schedule is then in effect. But the holiday rotation doesn't change. It just simply resumes as it's supposed to at the end of the special period.
I understand that. In the way that it fell, then he had the second half of break, which included the first weekend in January, that instead of resuming the every other weekend the next weekend, he wouldn't do that. So that was his weekend. And I agree with Lacey Gilmore that the order doesn't say, do you then resume the every other weekend as whoever didn't have the weekend before. So I'm not saying he necessarily violated a court order. I think there is some things that are a little bit unclear, but the way that he interpreted it made my client not have parenting time for almost a month with a child that she lives very, very close to. And so all I'm saying to the court is, can we just make it right to her moving forward with an order today And then we can fix the Christmas hopefully for next year so this doesn't happen again.
What do you mean right to her?
Say that?
You're asking the court to make it right to her.
Sure. What I asked for was for her to have one of his weekends in February so that he's had almost a month with the child because he has primary residency. So he also has the weekdays with the child and give her 3 weekends in a row. So that will somewhat help make up for the length of time that she didn't get to see the child. He'd lose a weekend, but he still would have all the weekday time. So at least then there would be that she could demonstrate to the child that she's involved, she wants to see the child, that and it would be a little bit more, you know, of a fair outcome for February since January was not fair. And then we can just do that for this year and then fix things moving forward.
Ms. Gilmore, what's your client's position on that?
Judge, she agreed to that schedule when they went to mediation or domestic conciliation before. She could have looked at the calendar and saw this means I'm going to have 3 weekends without my child. We got here to where we are with my client being the primary parent because mom has for extended periods of time throughout this child's life been voluntarily absent or uninvolved. That's how we got here. And now what seems to be happening is when she doesn't get her way, she'll ask my client for something. If he doesn't agree or acquiesce, then she's accusing him of alienating the child and saying he's doing something to prevent her from being in the child's life, which isn't the case. That's just how the calendar fell. My client looked at, okay, mom had the last weekend before parenting time. Then she had her holiday parenting time. Then he had his holiday parenting time. And so it would be his next weekend. That's how the schedule worked out. That was nothing my client did. That's just how it worked out. It's unfortunate that mom thinks that's unfair. But my client doesn't really see it that way. He was amenable to giving her a weekend that really wasn't her weekend, but based on her attitudes and behavior in front of the child, he didn't feel like that was appropriate. And in conjunction with them discussing the case with the child, discussing the scheduling with the child, my client is not comfortable and thinks that that's something that should be addressed in mediation when they're able to discuss the issues more in depth.
And Your Honor, my client doesn't discuss the court order or court or motions with the child, but the child does ask my client because the child wants more time with my client and doesn't like not seeing her mom more often. She will ask my client at the end of parenting time, when is the next time that I get to see you? And they do sometimes look at the calendar so that the child has the concept of when the next time I'm going to see you is. So my client doesn't talk court order or court with the child, but when the child does say, when is the next date that I will see you? My client does answer that question. So I think that's not being, that's being mischaracterized. My client also has a different version of what happened on January 9th, but she didn't even think the child was present at this exchange or when they were at the gas station discussing. But the fact of the matter is that he had the first half of the break, then he decided that that next weekend was also his weekend when my client contends it should have been her weekend. And that meant then that she went almost a month without seeing the child at all. And that's all I'm trying to rectify. I'm not saying he was right or wrong. He interpreted the order one way, she interpreted it another way. But the reality is that she went that length of time. And that's all I'm trying to do is to take a weekend in February to somewhat make that right, moving forward into mediation.
All right, Mr. You're arguing this as if somehow that Mr. Hayes did something wrong and he has to make up for it. If he was just simply enforcing the order as to what was,
I don't believe he was enforcing the order, though. I don't know why he.
You going to argue with me now?
Well,
Why don't you just be quiet a moment? Why don't you just be quiet a moment, counsel? If it was his weekend on the rotation, he had every right to claim it.
I don't know that
could an accommodation been made? Yes. But I don't see that this is a wrong to be rectified. He just simply followed the order and its rotation. The door occasionally could swing the other way, and that your client could be set up to have consecutive weekends with the child based on an evolving schedule. But I think there's going to be a very chaotic system in place if we're going to start changing the rotation of the weekend visits because of an intervening holiday schedule. Unless that's built into the order from its inception, And the court's not inclined to order any compensating time for him just simply claiming time he was already entitled to.
But my client doesn't believe that. She firmly believes that that weekend should have been her weekend. The last weekend that she had with the child was December 5th through the 7th. Then she had her first part of the Christmas break. So I don't know why, when her last regular weekend was December 5th through the 7th, why then her next weekend wouldn't be until January 16th, 17th, and 18th. And if she misses time, then she doesn't have weekday time like he does. So she disagrees with what that weekend that he took was his weekend. He says it was. You're saying he's enforcing the order. We're saying he didn't. He violated the order. But if the court's not inclined to make an order today about that, I mean, I guess we can.
Well, if there's some clarity that needs to be made to any other holiday or special period plan, then that's very, very appropriate to be discussed during mediation to avoid unintended consequences in the future. But your motion for makeup weekend parenting time at this time is denied. I also note that on January 13, you filed a motion for therapy for the minor child.
Yes, and there's some dispute between the parties as to who should provide therapy for the child. We may need the court's discretion on that. I guess my client's position was that the child, she would like to start therapy sooner rather than later, but if the court wants them to talk about this in mediation, then I guess we can argue it at the review if they don't reach an agreement in the meantime. But I don't want dad to move forth with who he selected. My client shouldn't move forth with who she selected at a minimum, I guess, if we're not gonna argue this one today.
So is there a concession that this child needs to be in therapy?
Yes. I think they both think that. They just can't agree on who to do who to provide the therapy.
Are there insurance considerations that need to be taken into account?
I believe she has can-care insurance.
I see from the motion there was a whole number of people that were discussed and proposed, I guess, by one party or the other without an agreement from the other side.
Essentially, Judge, what happened is my client in August wanted to re-engage the child in therapy. The parties seemed to be in agreement with that. At the end of August, mom proposed one singular name. The order requires that each parent propose 2 names of registered play therapists. She proposed one name, didn't really give my client much information. He couldn't really find any information about this particular therapist. So he then proposes in September, he gives the name Seth Hawk. Mom says, no, I think she needs a female therapist. She was only bonded to her teacher, Mr. Phillips, because he knew her since kindergarten. I think she needs a woman therapist. My client said, okay, let's find one that has, let's work together and find one. Well, then November 17th, mom sends him a message and says, hey, by the way, Paisley has an appointment with this chosen therapist that I chose that dad had already objected to. And says it's November 20th, which conflicted with an IEP assessment as well as a prior scheduled dentist appointment. So dad says, no, that's not going to work. You need to cancel that appointment. She has the dentist appointment you knew about in October, as well as an IEP assessment. And I haven't agreed to this provider. We need to find providers that have evening or weekend appointments or appointments that lessen the need to miss school. Mom, from that point on, just absolutely refused to consider any other providers. And in fact, my client learned after the fact that mom had a secret meeting on November 7th with this therapist and had a whole intake with this therapist without consulting my client, without giving him notice or an opportunity to be there. The first he heard about mom moving forward was in November 17th. On November 19th, he gave her some names and said, let's look at these therapists. These are females. They have appointment openings. Mom said, no, I'm not doing that. I've already had an intake with this therapist that I chose. Dad said, no, I'm not comfortable with that. That's not fair. He reached out to me. I reached out to counsel and I suggested that the parties maybe give a short list of 2 or 3 providers that they wanted to use. And if they can agree, great. If not, we can have the court's involvement. There is in their parenting plan a process for someone else to determine if they can't agree. And it was for the primary care physician to make that determination. So dad had all of the names, the 3 or 4 names, sent over to the primary care physician. He did not say which parent suggested which provider. And the doctor did send back a provider, and that is the one that my client wanted to go ahead and schedule with. He did reach out to them. He did get some paperwork. He did inform mom, hey, this is, the doctor gave us this recommendation. So there is a built-in procedure to use for I guess, to figure out which provider is appropriate. But mom is not in agreement with that. I tried to remedy this without the need to come to court, but nevertheless, the motion got filed. The bottom line is there's no objection to the child having therapy. My client fully supports it, but it needs to be someone that they've jointly selected and chosen, or that neither of them have selected and chosen. They did have previously some co-parenting therapy or assistance with therapists with Andrea Skelton and Brian King, who is mother's individual therapist. So, and I believe mom was not agreeable to reinitiating therapy with Ms. Skelton. So that's why they started looking at alternative providers in the first place.
All right. Is this referral from the primary care physician a male therapist?
No.
A female therapist that's not a registered play therapist, which is the order says that person needs to be a registered play therapist. They understand that she's still under training and working on her education still. But my client's issue is that she presented this person, that Heather Henry, that she thought was appropriate. My client did speak to Heather Henry to get some information and determine that she thought she would be a good fit. It's kind of hard to pick someone just off of a website. The child hasn't met Heather Henry. My client let dad know why she thought she was good. My client gave him her contact information, her website. Heather Henry, for safety reasons, doesn't publicly share her phone number on her website. Initial inquiries have to go through her website, but then there's a phone number for communication once you're a client. Dad then suggested Heather Hawk. He didn't say specifically he objected to Heather Henry. His message back was just, how about Seth Hawk? So my client, in her mind, thinks that's not even really an objection, but he suggested this other person. My client did say that she thought that the child should be with a female provider. Dad then suggested the person, Megan Waltner, who's not the licensed play therapist. Dad saying that he presented this to the physician for input. My client doesn't know if he did or didn't. She wasn't involved in that. She thinks maybe dad's wife did. I don't know for a fact. My client doesn't know for a fact, because she wasn't involved, that all options really were presented to the doctor, but the doctor picked the one that dad was advocating for, which my client has a concern about, since she wasn't involved. And doesn't know if the doctor was even presented her preference, or knows whether Ms. Waltner is not even really a licensed play therapist. So she should have been involved in the conversation with the doctor, and she wasn't. And my client is opposed to that therapist. So she believes that Heather Henry would be a good fit for the child. That's why she's advocating for Heather Henry. So that's why we are where we are, and why I brought this issue to the court. My client would like the child to begin therapy, but she doesn't agree with a person that's not a licensed therapist that dad has selected and is saying that the doctor has said would be a good fit. My client's got concerns over her license, and that doesn't follow the court order, and not being involved in the doctor's appointment, and the communication doesn't follow the court order. How this has all gone down is kind of a mess, but proceeding with this person is not what my client is comfortable doing. She would like Heather Henry, who she believes would be a good fit, from talking to her and determining that she thinks her child would be very comfortable with that person. And she has.
Let's identify what court order you're referring to.
Say that again.
Let's identify what court order you're referring to.
Well, joint legal custody would require notification and the ability to participate in medical appointments. There shouldn't be a, hey, the doctor said this and you weren't involved in the conversation. You didn't go to the appointment. We didn't tell you about it. But the court order specifies if there's a concern, then the issues need to be brought before the doctor. And so that would be the two parties bringing the issue to the doctor and being fully informed in the decision making, or hearing from the doctor what the doctor recommends to both of them, not just dad doing it behind my client's back. I agree with Ms. Gilmore that there is a pattern that the parties are supposed to follow. But it hasn't been done properly. And now my client has concerns about how dad's come to wanting this Megan Waltner, who's not a licensed therapist, and the court order says it needs to be a licensed play therapist.
Okay, again, I asked you what order you're referring to, but you haven't identified one.
Well, the order for joint legal custody, and
Okay,
then
wait a minute. You say that it has to be a licensed play therapist. Where
Yes.
does it say that?
in the memorandum of understanding, very specifically, it outlines that. And if you want me to find the page number, it's a big memorandum. I'm going to have to pull it up.
Date of the order?
It's the big last parenting plan that was ordered in the case. I apologize, I don't have the date in front of me, but I can pull it up real fast and probably find it in the file.
Judge, it's listed in the agreed domestic conciliation recommendation, the most recent one that was filed with the court. It is on page 20 of that recommendation, and it is paragraph 6 that discusses change in therapist. And what it says is, should a change of therapist for PH be needed, the following standards to be used. 1, each parent to research and provide the co-parent with 2 registered play therapist options within 30 days of discontinuation of current therapist, unless discontinuation is due to no longer having a need for therapeutic services. 2, parents to agree to therapeutic provider within 15 days after options are shared. 3, if either parent does not provide options to their co-parent via OFW within 30 days of the start of the new provider process triggered by the end date of therapy, the parent who has found options has the ability to move forward with the new provider. 4, the parents agree to a new registered play therapist for PH. 4.1, if they are unable to agree to a provider, the parents are to present the therapeutic options to the primary care provider, regular doctor of PH, and the physician will make the final decision. My client's concern primarily regarding Heather Henry, Judge, is that when I go to the Behavioral Sciences Regulation Board website and look for her license, there's no license listed there for Heather Henry for any sort of behavioral health, anything. No social work license, no therapy license, no counseling license. She doesn't have her own website as far as we can tell. What mom sent to my client was a resource website like Psychology Today, but it was a different sort of website. She did finally give him a phone number, but initially told him that she would not give him the therapist's phone number because she doesn't give it out. So my client did go to the website provided by mom, sent a message to the therapist through the contact us option, and still to this date has not received a response. I will tell you that I had my office call yesterday to that office, and my assistant informed me that when you call it, it's like someone's cell phone. Like maybe it was on Do Not Disturb because it went immediately to voicemail. But when the voicemail came on, it didn't say, "You've reached Heather Henry, therapist." It just said, "Please leave a message. We'll return your call." So my client has obvious concerns with that therapist. He can appreciate mom's concerns with regard to Megan Waltner. I can tell you she is in the process of getting licensure, which means she does provide play therapy under the supervision of a supervising higher up. Additionally, there was no appointment with the doctor where this happened. These options were just sent to the doctor saying this is the parenting plan requires the physician to make a determination between the therapist presented by the parents. Here they are. There was no conversation. There was no discussion. There was no, this is my therapist. This is mom's therapist. That simply didn't happen. It wasn't an appointment. And the doctor just sent back. That's the one name that he sent back. So there was nothing like that.
When you say he sent back, was this by email?
I think it's in the portal. There's a parent portal or a phone. It was a phone call. My client's informing me it was a phone call. He just called back and said, "Here's the name." Or his office did. It wasn't even the physician that called him back. So, I mean, my client just wants to find a therapist for the child, but does not want it to be Heather Henry given mom's secret appointment with her in November 7th, which totally violates the order of the court, which was that both parents are to participate in the intake.
Well, it would appear that the court should follow the lead of the primary care physician, and if the primary care physician, based on their knowledge of available community resources, chooses or at least designates this person, this Megan, as an appropriate play therapist, even under supervision, why would this court quarrel with it?
I don't know that he was given my client's preference. I don't know if I don't know what he was shared, what was presented to him, how it was presented to him. If it was, I want this person recommended, or is this person, so without knowing how it was presented, my client is very uncomfortable with it. I don't know if he was given Heather Henry as an option. I don't know if he was pushed to say this person is a good person. My client wasn't involved in the message at all. She wasn't copied on the message. She wasn't told ahead of time that he was going to be reaching out to the doctor.
But if the parties both agree that play therapy for this child is necessary, why don't we just get this started?
I had 3 appointments. 3. I know. My client would just prefer to be with someone that she feels comfortable with and that she thinks will be a good fit. But I understand it needs to start, hence why I'm here asking you. But I think just because he doesn't trust who she's picked, now we're wanting her to trust who he's picked, and there's not a lot of trust in this relationship.
Well, unless there's been material misrepresentation made in this court this morning, he didn't choose. Apparently, he presented names to the doctor, and the doctor chose.
I don't know if that's the case or not, because my client wasn't involved in the communication.
The officer of the court has represented that. Well, I think you touched on the stark reality here. Neither parent is going to agree on a play therapist chosen or which the other parent is comfortable with. So ultimately, it needs to go to a third party to make the decision. I think that they set up a procedure in prior negotiations to allow the primary care physician to make the choice, and that choice has been made. This court has no reason to oppose it at this point, and the court will order that the primary care physician's directive be followed and that the parties at least initiate or at least try a play therapy with this individual. She very well may be just the one that the child needs. And let's get this started relatively soon. I think the contention that we've shown on relatively minor issues this morning underscores why this child very well may need therapy. All right. We're on a path toward mediation, a path toward therapy for the child. And the court did want to establish another status conference date to review progress. Ms. Gilmore, your estimate, realistically, presuming a February 11th, I think was the date, start to the mediation, what would an anticipated period of mediation be?
I would think they will probably need at least 2 sessions. So if they get in the middle of February, I would think they could probably get in a few weeks later at the beginning of March. So if we set maybe the middle or end of March, I would think we'll know by then whether they're amenable or not.
Sir, would you oppose what Ms. Gilmore suggested?
No, I think that makes sense.
All right, your availability on Monday, March 30? Counsel?
I'm available all day that day.
Okay, I heard one response.
I gotta pull up my calendar real fast. I apologize.
That's quite all right.
I'm free anytime after 9:30.
All right. I'm contemplating an 11 o'clock a.m. All right, this will be a Zoom review hearings similar to today to review the status of the matter and particularly progress made in mediation, perhaps even a report on the progress of play therapy for the child. Monday, March 30, 11 o'clock a.m. Again, the court strongly encourages the personal presence of the parties themselves. Monday, March 30, 11 o'clock a.m. All right. Ms. Gilmore, there are some things that I think need to be documented in the file stemming from today. I'm going to ask you to draft an appropriate order upon the review hearing and status hearing held today,
Yes, Your Honor.
documenting any of the court's orders or directives made here this morning.
Your Honor, would you like that order to document that mother left the hearing in the middle of it? Or-
She's still here. She's in the room. She's just pushed her chair back a little bit. She's
Okay.
here.
Okay, that's
So
fine.
no, and if you'll get that circulated as soon as practicable under the circumstances, Ms. Gilmore.
I will. Thank you.
Okay, all right. Is there anything else we need to address today?
No, Your Honor, thank you.
All right, Ms. Gilmore.
No, Your Honor, thank you.
Very well. And at this time then, this matter will currently be in recess, and this meeting may be ended for all at this time.
Share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns.